Good morning. We're going to move on to the third and last roundtable of this first session of the fourth international conference, dealing with a really interesting topic, the UNIDROIT principles on digital assets. Very briefly, I'm going to thank Professor Carmen Pastor for inviting me to participate in this conference and also to be able to chair this roundtable. I'd like to thank also Professor Martínez Echevarría and Professor Moran. And I'd like to congratulate you because the quality of the conference has already been proved. And this is a very important and interesting initiative to regulate the content of these principles that are going to be a fundamental tool for the running and knowledge and practice of digital assets to reach all sectors that are necessary. This third roundtable is going to reach the next section, custody. It consists of 4 principles that are going to be commented by 3 speakers because principle 10 and 13 are going to be addressed by the same speaker. And without further ado, we're going to give the floor to this principle 10, custody, that is going to be considered by Nicolas Agustatos from the University Pablo de Olavide. Nicolas Agustatos is a professor and represents our dear Professor Madrid Parra. Nicolas, you have the floor. As it's been said, microphone, please, yes. I've got so many pieces of paper here. I'm here, come here on behalf of Professor Madrid Parra that will participate on Friday, and he's given me his principle. I was commenting this with Carmen and David. This reminds me when we were students and you asked a friend, the best student, for his notes. And when before the exam, you were studying and saying, what is this about? Well, this is a kind of the situation I'm facing at the moment. I mean, we'll try to do it the best I can because it's a complicated issue. Principle 10 is entitled custody, and from the beginning of the working sessions we've seen that many of the investors in the market require the presence of intermediaries to see the taxes of the digital assets that they have. These has different problems as to what figures can be present in the custodian figure, and also the setup of these digital assets as an intangible asset where control by 2 identical persons is not possible. So there are challenges like how can we limit the absolute possession of the owner if they can dispose it or have warranties or of an asset that is not of his own or her own ownership. We have the multiple signature option. Although it says at the beginning in the principle that even if the intermediary is the one in charge, the decision to dispose and to create warranties on assets is going to require always the permission of the holder. We have questions like what would happen if the digital asset is managed by an individual asset, or what happens with the traceability of those digital assets? How can we solve this? Can we manage it through different accounts? There is another problem with an international or cross-border concept, as Professor Miguel Ángel Pendón would say. How can we approach solutions that arise as guidelines in legal systems with different nature, common law, civil law? How can we solve this situation where the one in control is the one that has absolute powers over the digital asset, but he or she is not the holder? In common law, we have the trust figure, but in civil law, well, we have the deposit of fungible things, where the one depositing loses control over the one that receives it, the credit claim, etc. So it's also true that in our law we have we can decouple that the person in control of the digital asset and the owner. And there are other circumstances that I invite you to have a look at or to listen to Professor Madrid's intervention on Friday. So I'm going to move on straight on to Principle 10. I don't know if he's following me through Zoom, whether he's controlling what I'm saying, or whether I'm linked with him. I don't know if he's stalking me or not. I'm going to move on straight to Principle 10. That is divided into 4 sections. The first one is about the subjective circumstances of the custodian. That is the natural or a legal entity that offers the custody service in favor of the client. We have the figure of the client, the beneficiary of the custody, and the sub-custodian, that is the custodian of the custodian. There is a concatenation of custody agreements, one between the client and the custodian, and then subsequently another contract between the custodian and the sub-custodian, where the custodian is the client and the sub-custodian is the custodian. So in brief, the ownership is still on the client or by the client, and the control over the custodian. We have to see what happens with the intermediary custodian. In our law, we would say that it's the immediate possessor or control, immediate intermediate controller. Well, Agustin will be able to answer this on Friday. Anyway, Section 2 talks about what we need to understand by custody service, and we understand it as managing a digital asset for the client, keeping control of this asset. To see what we understand by custody service, we need to understand what is control, or what control is. After the magnificent presentation from Marina Echevarria, I'm going to keep my mouth shut, because it's already been magnificently explained by her. Because it's difficult for me to understand, but the idea is that to understand what a custody service is, we need to understand control. And control means to have complete disposal of the asset in the terms that Professor Marina mentioned before. In the third section, we talk about this objective element and is the contract, the aim of the contract. The custody agreement there has to be an agreement, a contract, and in terms of principles, not every situation can be considered as a custody. There are 3 requirements. Even though there are not 3 of them, there are 4 requirements. We'll see that there's an extra one, but there are 3 in principle that are noted in Section 3. First, services provided in the service provider needs to manage the digital asset for the client. And third, the client doesn't have the faculty, the exclusive ability to change the control of the digital asset within the meaning of Principle 6.2. In principle, any situation that fulfills this requirement should be considered as a custody agreement, but this is not the case. The definition of custody agreement, depending on the meaning of the principles, demands these 3 requirements plus a 4th one. That is the 4th one. And this is an additional one, that is the final one, and is determining is that an agreement, a custody agreement is clear from the agreement that if the service provider enters into an insolvency-related proceeding, the digital asset would be part of the service provider's assets, available for distribution to its creditors. The digital assets that he or she controls and manages for his or her clients will not be part of the active mass. And fifth, not always the contracting client is the owner of the digital assets. It can be a third person that acts on behalf of the owner and meeting the possibilities of representing different representation structures. And on behalf of Professor Agustín Madrid, thank you very much.
Thank you very much, Professor Gustatos. I'm sure Professor Madrid will be satisfied regarding your intervention. And you're going to be on standby at the moment, because now we're moving to Principle 11 of the fourth section, that's called duties owed by a custodian to its client. And to explain this principle, we have Professor Bustillo Saiz. She's a colleague from the Department of Commercial Law from the University of Valladolid. She's a professor, full professor, and you have the floor. Sorry, microphone. First of all, I want to thank Professor Marina Echevarria, my colleague from my department. I want to thank Professor Carmen Pastor too. I had the chance to know other professors here in the room. Thank you very much. It's a pleasure for me to be here, and it's a bigger pleasure to be able to discover the existence of these principles that I find really interesting, and other principles that I think should be directly attached. And that leads me to dealing with Principle 11. First of all, I'm going to mention something that Professor Morambovio already mentioned, and Professor Carmen, regarding concepts used by these principles, because in my principle, it is clear that there's no custody if the custodian doesn't have some duties. And this is the axis. Well, I wouldn't call it axis, but states are requested for these principles to be made as something essential. They have to keep the assets, maintain the assets, and these are the duties of a custodian. So this is something important to be taken into account from the point of view of principles. And on the other hand, we are talking about crypto assets, and we have realized that at a practical level, in many cases, it is essential to avoid intermediaries. So in the preparatory works, the question was, why should this principle be dealt with? And of course, this has to be observed in the different regulations via MICA, via investment services, etc. But I think that it is really interesting to see this perspective and to analyze these principles from the point of view of private international law, because we understand their extent even better, and we understand the limitations they have when establishing the duties, and regulators are the ones that have to fine-tune, etc. So starting from this idea, this principle is structured in 5 subsections. The first one defines duties regarding the custody agreement, and these duties are the prohibition of the custodian to transfer the digital asset on its own interest. The second one is the management of the assets in the management, the custodian has to be the holder. And the third one is that the custodian is obliged to safeguard the digital asset. Regarding these duties, the first one is directly connected with the definition of custody, because there are situations of the prohibition to manage directly, but sometimes transferring that management is complicated, and it analyzes that authorization. To which extent does it exist? What limits does it have? So in this case, if there's a custody agreement, and if that custody agreement does not clearly state that those assets are part of the custodian assets, it is not part of the interpretation. The custodian has to recover them, because that's the main duty of custody. And that means that they're not going to be subject to insolvency of the custodian. Holders are not going to be subject to the insolvency of the custodian. Something else related to these principles was the source of these duties, if it has to be followed, or if there are nuances. Now it's been said that there are nuances, and it can be redefined by different laws, by agreements. If in case there's a guarantee that's created on behalf of a third party, or even a right of use to limit the scope of the instruction. So as the English jurisprudence stated, there's no obligation to follow up that questions the role of the custodian. It is very interesting to see the difference between fungible and non-fungible assets, as it was stated before. At first, there were doubts on how the concept of fungibility is related to these assets. The principles say that there's no obstacle to individualization, but according to the preparatory work, we saw that there are problems, because if there's an undivided fund, the custodian, even if it has its own internal registration, the custodian is going to have the percentage that corresponds to each holder. But the fact is that there's no direct reference that links the custodian to the holder, but they are just related in those omnibus accounts. And the problem is that transmissions are going to take place not just through the distributed registry or record, but through the different entries in the ledger, and that's going to be kind of complicated. So that's the situation we're facing. Then, as for the optional duties defined by this principle, it does not seem to be possible to distinguish between imperative duties and optional duties. If we follow up the different duties from the point of view of private international law, this is difficult to analyze, but these optional duties, the fact that the custodian has to follow a register or keep a register or record, they have to be registered regardless of the instrument. and they have to be managed safely, and they have to be equivalent to the ones in the register, and it is obliged to have an amount of assets that's similar to the ones stated in the register. So in case one is lost, and this is a very frequent risk, or in case the asset was sent to the incorrect address, the custodian is responsible for that. So responsibility is not up to individual owners, it's up to the custodian. The custodian has the responsibility because he or she is a professional person in charge of, is a professional in charge of the management. Something that's very interesting and that is related to the first optional value is the need to segregate digital assets from clients to be able to safeguard or for them to keep them safe from the from different situations, and to identify them in case of bankruptcy of the custodian. And related to benefits, the custodian is obliged to distribute benefits and dividends. There seems that there's corruption, because if there's a division in the network, different people in the network have the right to receive some money, and the situation seems to be different in France. But there's the possibility of using a sub-custodian. But the important thing to highlight is when the custodian uses a sub-custodian, the client has to have the same guarantees. So the sub-custodian has to be subject to the same principles as the custodian, and to the principles that the states have decided to make binding and compulsory. And I think that's all. I don't think it took too long. Sorry.
Thank you very much for your presentation. It's been very interesting. For the time that we had, is quite profound about Principle 11. Principle number 12 is about the innocent client, and we have Esther Becerril. She's a lawyer, a practicing lawyer, and doing a PhD in commercial law in the University of Valladolid. And her intervention is not going to be face-to-face, but she's going to connect online. Esther Becerril, are you ready? You have the floor. Can you hear me now? Okay. I'd like to thank you for the presentation, and it's an honor for me to be able to participate in this collective work and to participate in this forum with experts, especially Marina Echevarria, my mentor, regarding the principle. Is Principle 12, innocent client. We have to carry out a comprehensive analysis of the structure and the final text of this principle after having revised the constitutional process of it. This is the third principle of the fourth section of principles devoted to custody. So the principle has to be understood within the legal regulatory framework, take into account the previous interventions the concept of custody. Regarding Principle 12, there are many references to Principle 10, custody itself. The principles define custody as a relationship where a custodian has to safekeep the digital asset, but not in the benefit of the client. This way, the custodian normally has different situations. There are situations of insolvency of the custodian himself. In brief, the whole section it has to be analyzed in different perspectives. The concept of innocent client was analyzed in December 2020 by the Working Group on Private Law and Digital Assets. It was very difficult to express the concept of negotiability until the different type of digital assets included were conceived. The UN Commercial Law Group said that they couldn't take into account the whole market. The aim of the project was to see if it was transferable or not, but they focused on the protection of innocent clients regarding the validity of transfers. There was a group of new digital assets that we needed to bear in mind different agreements, and the conclusion was that we needed different issues regarding the purpose of the innocent acquisition, similar issues regarding the intermediated securities. It was necessary to refer to regulatory aspects regarding the project in terms of negotiability, and the innocent acquisition referred to two types of rules, applicable and non-applicable, depending on whether it was innocent acquisition or not. Esther, could you please speak a little bit more slowly because there's interpreting going on? It's necessary to start from the principle, the idea that Principle 12 on innocent client, it starts from the innocent acquisition in Principle 8, but adapted to specific circumstances regarding custody. The rule has to be adapted to each level of custody. If there is a relationship between a sub-custodian and a custodian, the principle of innocent client would be applied to the latter. The protection of the innocent client would be carried out following Principle 8 or Principle 12. Particularly to see the principle, the text proposed on the Principle 12 is structured in 3 sections, to which are followed by commentaries 1 to 7. The main aim is to avoid complaints about the client. The first section refers to good faith or innocent client in custody situations to avoid claims of the ownership of assets. And the custody means the control of the asset, and we have to see who is the owner in each case in particular, because custody because we have to see who's got the control, and there can be different situations. On the one hand, if there's no custodian and the owner is custodying it has complete control or not. If the custody is not carried out by someone and there's a contract with a third party that is keeping custody of the asset, and the owner doesn't have control over it, so it will be the custodian or sub-custodian who is in control and has to safeguard the asset through a contract. So the important issue is control. The person having control, whether it's a custodian or sub-custodian, will have powers to dispose of the asset with the legal consequences derived from this. As a result, the legal consequences about owning an intangible asset has different consequences regarding custody, guarantees, deposition, or transfers of proprietary assets. Based in this content, it says that no complaints should move forward regarding digital assets because it's the custodian, the one managing it, and not the client. The third party that can be involved in the change of control doesn't have the power to present a complaint to the owner of the asset. However, in spite of this, the Principle 12 doesn't mention the case where the client himself can give a real right to a third party. The second section of Principle 12 has to say that it has to be applied depending on the level of custody. If there is a custody chain where a client intervenes, a custodian and a sub-custodian of the digital asset, the Principle 12 should be applied linked with the relationship between him or herself and the custodian, so a third party cannot complain on the direct right if the one in charge of management is the sub-custodian. However, at the same time, Principle 12 says that it has to be established in the relationship between the client and the main custodian. Finally, the third section of this principle mentions two possible scenarios that can take place in practice in real life, where we need to distinguish if the custody relationship existing at the moment is applied to Principle 8 or Principle 12. There are three examples that are quite clarifying. The first two refer to different contractual relationships for which Principle 12 cannot be applied, duties and rights of transferees and rights derived from an agency contract, where we have to apply Principle 9 or Principle 8 respectively. Therefore, in conclusion, Principle 12 is a closure clause that protects the client to safekeep the client from any responsibility that may be claimed, excepting those cases where the client knew the bad management. In the commentary I've carried out, there is a deep analysis that can be borne in mind as a mirror to develop an own legislation. For instance, Article 609 of Spanish Code about transfer of responsibilities. This document, Principle 12, refers to the Civil Code, Article 432, 34, and following, subsequent, and also we have to take into account the content of these articles. For instance, Article 2 of Title 18 on the prescription of dominance and other rights. In the commercial dimension, there are the claiming of the Spanish commercial law. And regarding procedural law, we can analyze Article 34 of this law. And also, we have to analyze trusts in common law. We need to develop this principle in the commentary that I'm mentioning. As a conclusion, Principle 12 is a principle, a closure principle that wants to provide further legal certainty to digital assets and at the same time facilitate the drafting of all this. Thank you very much.
Muchas gracias.
Thank you very much, Esther. To finish off this fourth section, we have Nicolás again, who's going to talk about Principle 13 related to the insolvency of the custodian. Hi again. Microphone. Good afternoon again. I'm going to talk about Principle 13. That's what I understand about. This is my principle. Principle 13 is called insolvency of a custodian and creditor claims. But what this is about is it deals with the insolvency of the custodian. It is made up of 8 sections. But point 1 doesn't deal with insolvency at all. Therefore, despite the title, it deals with the insolvency of the custodian. The Principle 13 is not the only one dealing with insolvency. There are others. For example, 19. But 19 has to do more with creditors and non-insolvency of the custodian. That's why this has been placed in section 4 related to custody. Having said that, I'm going to deepen into the main content of Principle 13, and I'm going to be dealing with these interesting aspects. The first one is insolvency, the insolvency situation itself. It is clear that there are many digital assets in the hands of custodians. Most investors need custodians to keep their digital assets. And then we wonder what happens when the custodian is under an insolvency proceeding. We've got different examples such as MT Gox, BitGrail, or Cryptofia cases. Principle 2 states, if a custodian enters into an insolvency-related proceeding, a digital asset that it maintains for a client under custody agreement does not form part of the custodian's assets available for distribution to its creditors. So, despite of the length of this subparagraph, the provision is very clear. Digital assets in charge of the custodian on behalf of the clients cannot be subject to, cannot be attacked by creditors. So from the point of view of bankruptcy or insolvency, and here we have a room full of people who are experts, the holder needs to be able, this is known as separatio ex jure omni. This always applies when the custodian uses the figure of the sub-custodian to control digital assets. In this case, in case of insolvency of the custodian, the rights that he has in relation to the sub-custodian are not part of the assets of the insolvency state. And point 4 states that the necessary measures need to be taken to recover those assets. That is, to recover the assets to another custodian, to the owner, or to another custodian. That's the content of point 2. There's another interesting thing. That's the other principle of point 2. That's the situation of a shortfall. That is reflected in other parts of the principle. Shortfall implies some requirements. Those in point 13.5. First of all, a custodian has to enter into an insolvency-related proceeding. I hope Professor Carmen was going to define this, but as there's another principle related to insolvency, that's principle 19, this is up to our colleague in charge of principle 19 to define that. But it is included in principle 2.6 and in the commentary 2.6. So point 2 says that digital assets are of the same description, are maintained by the custodian for 2 or more clients as an undivided pool. So all these assets have to have the same features, Bitcoin, Ethereum, or whatever. Another requirement would be that the custodian manages these digital assets of the same description via an undivided pool. As my colleague mentioned, it can be done via separate accounts. But for the shortfall situation to take place, the assets have to have the same features, and it has to be done via an omnibus account or an undivided account. And the third requirement for the shortfall to take place is for shortfall to be there. And how is it defined by the principles? Principle 2.6 refers to principle 13.5. letter C, which states the quantity of digital assets maintained by the insolvent custodian for those clients is less than the aggregate quantity of digital assets of the same description that is obliged to maintain for those clients. That's a shortfall. I understand that a shortfall takes place when the amount of digital assets with the same description that the custodian manages on behalf of his clients is higher than the amount of digital assets of the same description that the custodian controls at that moment for his clients. That's when the shortfall happens. And what are the solutions offered by the principles? One of them is optional and the other one isn't. The optional solution is that the shortfall is met first by any digital assets of the same description maintained by the custodian for itself. That is, for the digital assets owned by the custodian. You can see that this means acknowledging in the insolvency proceeding, acknowledging a privilege, because those digital assets owned by the custodian should be part of the estate, of the custodian estate. As this implies a privilege, that's why this optional regulation has been included. If it is applied, the shortfall will be covered by the digital assets owned by the custodian. If it's not covered, then we have the following rule. That's point 13.7. What does it say? It says that any shortfall shall be borne by the clients for whom the custodian maintains the digital assets as an undivided pool in proportion to the respective quantity of digital assets of the same description that the custodian is obliged to maintain for those clients. That means, I'm going to give you an example. If it's Bitcoin, the custodian's Bitcoin's assets will be used. If we don't use the concept in point 13.6, then we'll move to point 13.7. But what happens if there's still a shortfall? There are no more assets to use. Therefore, the principles state that the holders will be subject to insolvency. Before I finish off, I would like to thank, I was too nervous, sorry. I have to thank the organizers, Carmen Pastor, you too, David Moran, Professor Martínez Echevarría, the University of Alicante, and of course, all my colleagues from Valencia. Thank you very much.
Muchísimas gracias. Según me
Thank you very much. According to Professor Carmen Pastor, we can have some time for discussion now. So we're going to open the floor, not only regarding the content of this roundtable, but regarding the different roundtables that we've witnessed today.
¿Preguntas?
Maybe we can continue compiling doubts and have discussion later on. I don't know. I'd like to congratulate you all. Let's see if I can ask a question properly. I'm not an expert in commercial law, and I'm not an expert on the principles that you've been drafting in UNIDROIT. But I have a problem regarding the analysis of legislation that has been carried out in Europe and in the US regarding artificial intelligence. And more precisely, I tried to understand one of the key concepts of the new regulation that I think is related to something that you are carrying out internally, and it's what the concept that is partly new, partly not, the value chain of artificial intelligence. What does it mean? What does artificial intelligence contribute in the industry with, and where we can measure the value chain, and a new application of the value chain that is, for instance, in the application of rights. When we talk about value chain in the application of rights, of human rights, for instance, something that I'm quite surprised to hear. But it's being used before without having defined it, and the principles that you've been working with, it's very interesting to see that you're studying the value chain that is produced when there are transactions, rights, transactions and transfers, i.e. when, for instance, in the new Bitcoin markets and cryptocurrencies, that can be used as digital assets or as currency, but this involves the decentralization process. This involves having different types of governance, not only one, and to reflect upon the role contributed by technology and the different formal languages of artificial intelligence and of the systems. I'm thinking, for instance, of projects of our own in the industry where the relationship between machines, the different types of robots, and the infrastructures of platforms in an economy divided by platforms create disruption, but also what we call ecosystems or legal ecosystems. That is a concept that I like and that is not ready yet to be used. So I would like to ask a question, which is how can artificial intelligence, new AI processes in a symbolic or sub-symbolic way, how do they become part of the reflection of the principles that you're defining in UNIDROIT? That would be the first general question. And the second one would be if you can help me to define the concept of value chain that I don't quite understand because we don't have the metrics yet and we don't have the risk systems yet to draft them in a clear and legal way.
Si tiene la palabra.
I'm going to give the floor to Teresa de las Heras. Thank you very much. I'm going to come up with a response for the interesting questions. I'm going to start with the last one. Effectively, in the European Union, we're using in an interchangeable way and that has been criticized supply chain and value chain. It's been chosen to supply chain in the directive that talks about logistic chains, but we talk about value chain when we're talking about AI. And this is interesting because value chain in the regulation is solely the way to limit the personal dimension of application of the regulation, i.e., what actors of the supply chain of AI, of the value chain of AI, that starts with the designer, manufacturer, that goes to the distributor, importer, that has actors like the trainer of the one in charge of fine-tuning the system, and that reaches the person in charge of the deployment, what obligations have to be applied to each actors. So the question is interesting because it's proving the difficulty to apply the logic of logistic systems, pure pipeline, when we talk about systems as peculiar or particular as AI. And regarding your first question, the UNIDROIT principles on digital assets don't refer to, or obviously refer to, AI systems or AI models of general use explicitly, without detriment that they may be part of the structure, referring to some smart contracts that Marina mentioned before. Marina? Yes, very briefly. I don't have anything to add to what Teresa mentioned. It's true that AI is the only tool that is allowed to generate ecosystems that you mentioned that are crypto active, because bear in mind that there are issuers on the one hand, but then we have exchanges or markets that exchange those assets in chains that are decentralized without any subject in control. So as a result, the same assets can change from different exchanges, and the only ways that are valid for a fast transfer inter systems or inter markets are AI machines. That's why I was referring to smart contracts. This has legal consequences. It's not the same thing to transfer assets within the same custodian. AI machines or smart contracts are under the legal responsibility of one sole custodian than when we transfer them to different custodians or smart contracts with different custodians. From a legal point of view, this is going to have a consequence, but the only one that can carry out the traceability of control at the end of the day are these AI protocols. And here, sometimes we don't have a reflection in the registries in the chain. Sometimes we have digital assets that can be deleted. Finance says at some point, if you wish, we can delete the traceability of the asset, and you start from scratch, and you have a resulting asset, a new one, but you've deleted the whole traceability. So what you can have at the end of the day is the traceability of who has been in charge or in control, and of the intervention of a smart contract. So in this sense, there is a substantial contribution. Ignacio Lamillo wanted the floor. I wanted to make an observation regarding what has been said before regarding the concept of supply chain and value chain, because there are different concepts. And when we talk about supply chain, we include all the cybersecurity regulations in the process, the directive on cybersecurity number 2, because we have supply chains that depend on everything, and these depend on cyber supply chains. It's been published in the official journal that, depending on Articles 21 and 22 of the Cybersecurity Directive number 2, of minimum controls that have to be implemented for any technological product in the supply chain, and this affects those providing digital services in any type, subject or not to MICA. So there are concepts that are different and that do not fit exactly, and we need to offer both. I'm skipping the protocol, but very briefly, I was surprised when in European projects with large industries, not only technological, but of different supply chains, value chains, industries that manufacture chips or antennas, or there was another one manufacturing lifts or elevators. We are in the production processes. Each one of these industries, in an internal and confidential way, has their own studies regarding risks, regarding what can be produced externally, competitors, also clients, but also within the internal value chain of the product that they're launching. This is being measured. So the topic of simulations is key to define this. I think I was going to close, but I'm going to give the floor to my colleague.
Just quickly, if you have a look at the regulations on the artificial intelligence, I think this is a huge fraud, and I want my opinion to be clear. And in fact, I took part in a project on the regulation that was presented in Madrid yesterday, directed by Professor Cotino. The only case when there's a serious control is the IA applications, high-impact AI application that affect safety, like inhibitors, vehicles, and the application of AI to industrial economy, pure industrial economy. The rest of it hides an absence, a total absence of control. The rest of things are wonderful, but everything is hidden behind a very complicated situation. Any other comment? Any other question? If there are no more questions, we're going to finish this roundtable and the morning. Thank you very much.